Jack Smith's case against Donald Trump keeps getting stronger and stronger. The more time that passes, the more he can keep investigating the case. There is a freeze on the case, right? The defense doesn't have to do anything because it's in the process of being appealed. And as a result, when you appeal a case, and this is the case in Washington, D.C., in front of Judge Tanya Chutkan, the election interference case culminating in January 6th, that whenever you appeal a case, it divests the court of jurisdiction, and now the appellate court has jurisdiction, and the defense is relieved of their obligation or the burden that they have in order to have to handle a case, appear on the case, do anything on a case, frankly, that's substantive. And so it's questionable whether you were allowed to, or whether Trump was allowed to appeal Judge Chutkan's ruling at all about presidential immunity. But regardless, that's the posture we're in, because most of the time, as I'm sure you know, you have to appeal after any conviction. You're not allowed to do this midstream, in the middle appeal, but there are a few instances where you can. And like I said, it's debatable whether this is one of them, but regardless, that's what's happening. And so Judge Chutkan had to press pause and isn't allowing anything to occur except Jack Smith can keep investigating, interviewing witnesses, prepping for trial. He doesn't have to stop, right? He just can't burden the defense or ask the court to do anything. Now, he has filed a few documents as well, and he's filed discovery. And if you recall, Trump, through his lawyers, asked that Jack Smith be sanctioned and held in contempt for doing that. Some people think it was inappropriate for Jack Smith to do it. I personally think that it would be okay for Jack Smith to do it, since he can continue doing stuff. Anyhow, that's what's going on in the case. But while he is continuing to investigate and prosecute the case, one of the things he filed during this period of that we're on pause was his motion to talking about other evidence, or evidence that he wants to bring in. He also filed something talking about evidence he wanted to preclude from the Trump side, saying this stuff is inappropriate. But he's filed this motion saying this is the other bad acts evidence, or Rule 404B evidence, that he wants to, if it's Federal Rule of Evidence 404B, and in New York we call it Molineux, MOLINEUX evidence, which is just prior bad acts evidence or other bad acts evidence that is outside the scope necessarily of the written words in the indictment. It's relevant to the case. It's just not necessarily right there in the indictment. And so by doing that, by filing that, we definitely got a window into what was going on with the case and how Jack Smith's case is getting much stronger, and is much stronger than the January 6th select committee of the House that put together evidence. And why is that? Because they did not have subpoena power. They could not subpoena witnesses and demand their testimony and put them under oath and require them to testify before a grand jury the way Jack Smith can. And Jack Smith can also do things like search warrants for telephones and electronic evidence, et cetera. And so he has really developed a strong case, which we all knew he would have, because that's what prosecutors do, right? They keep going, they keep investigating, and frankly, you'll keep building a case until it ends up going to trial. This pause, if anything, helps Jack Smith, because he doesn't have to spend all his time answering frivolous motions that Trump and his lawyers are filing. He can spend all his time really making his case stronger. So a journalist and legal commentator whom I admire, Jennifer Rubin, wrote an op-ed in the Washington Post today saying exactly this, that Jack Smith that the case has gotten much stronger. And over the past month, we've gotten a window into what it is. So I want to just talk a little bit about what Jen Rubin has highlighted as what she thinks is much stronger. And she does it by looking at other reporting, whether it's ABC News or Just Security, which is this incredible, very well-researched, reputable, not-for-profit. It's called Just Security, that if you don't follow it, you should. They have put together a calendar of all of Trump's events. They have there's a clearinghouse of all the relevant documents that you need. And they also have some great articles in addition to MeidasTouch.com, which is obviously I am partial to. This is a great clearinghouse of information for all things Trump. And they have some very, very smart, excellent people who contribute. And so I just wanted to also credit them because Jen Rubin's piece does as well. So essentially the information that she was talking about in her op-ed is, first of all, the federal grand jury. Again, remember, one defendant, 4 charges, tightly drawn case, very, very, very surgical, as Michael Popak likes to use that word, based on provable facts that, again, most of us know what they are. But these documents that Jack Smith has filed have really given us this window as to what he has. So that's why we like to interpret it for you. So Jack Smith filed this document, and in it said basically a campaign employee, also known as his agent. Popak says that's Boris Epstein, and I would believe anything Popak says because he has an encyclopedic knowledge of these facts. And so let's say it's Boris Epstein, tried to disrupt the vote count in Detroit on November 4th, 2020. This is more than merely exploiting other people's violence. This is taking an active part in creating chaos. So that's a kind of a huge piece of information that Jack Smith has. I don't know if he has Boris Epstein cooperating or somebody else who's going to talk about this, but that he actually went to Detroit and tried to create the chaos, right? He tried to create the disruption of the vote count. He wasn't just merely exploiting other people's violence, which is what a lot of people thought Trump and his cronies were doing. They took an active part in creating this chaos. And let's not forget that Trump repeatedly and falsely claimed there was election fraud in Detroit when, as Jack Smith says, in truth, Trump's agent was seeking to cause a riot to disrupt the vote count. So Smith is alleging, therefore, I would say in this document, I would say he can prove it, because he wouldn't allege it if he can't prove it, that a Trump campaign employee, aka Boris Epstein, sought to cause a riot, not just use violence by third parties after the fact. Now, Jen Rubin doesn't say who this is, and neither does Jack Smith in his filing, but we think it's Boris Epstein. I keep wanting to say Boris Epstein, but it's Boris Epstein, given some of the conduct that has been described by Smith in his other filings. So Trump continued to lie about the vote count in Detroit, even though Bill Barr told him there was nothing to support this. So you can expect Bill Barr to be a powerful witness at trial for Jack Smith, because I think that will be just incredible evidence, because Bill Barr repeatedly told him, after doing these frivolous investigations into fraud claims that Trump was making, he would tell Trump there isn't anything, there's nothing there, but Trump wouldn't listen. And so he's going to be an incredibly powerful witness. And Smith in his filing went on to say that evidence of defendants' post-conspiracy embrace of violent and notorious rioters is admissible to establish his motive and intent on January 6th. So again, these are when you're talking about other bad acts, evidence, or uncharged crimes, you have to give a reason why that's admissible in this case. And one of the reasons under Rule 404B is if it goes to prove motive or intent. That's when you can bring other prior bad acts or criminal evidence in. Trump also cited his. They also cited Trump's post-indictment statements that were sympathetic to the Jan 6ers, right? Calling them patriots, saying he's going to pardon them, playing their national anthem at his rallies. I mean, he loves the rioters, right? The insurrectionists, the people who are serving 20 years in prison, the Oath Keepers, the Proud Boys, etc. And but Jack Smith wants to bring that fact in, right? Why is that relevant to the evidence? This is post the indictment, but why is that relevant? It's relevant because it goes to his criminal intent and his corrupt intent, which is an element that Smith has to prove, right? So, as recently as Tuesday, he said there'll be bedlam if he loses. That's a dog whistle to his followers that they should create violence. They should wreak havoc. He knows this, right? He knows when he says these terms, what will happen when he calls for death and destruction. Proud Boys, stand back and stand by. And Alina Habba in his New York civil fraud trial, basically today, saying that this is personal, and Cliff Roberts saying that this will be Trump's legacy, or actually that was Chris Christ saying that this will be Judge Engoron's legacy if he convicts. I mean, these are all things that are like, this was on the heels of Judge Engoron having a bomb threat at his house, by the way. And so these are all, I think, messages that his followers hear and know when Trump calls for bedlam, right? Or when Alina Habba sends a message to Justice Gorsuch saying that in Trump's immunity case, right, in the DC Circuit, that it's going to go to the Supreme Court in the presidential immunity case. Actually, this case, but the presidential immunity argument in this case, Alina Habba sent a message to Justice Gorsuch saying that Trump went through hell for him to get him appointed and expects him to do the right thing. The message is clear, right? We all know what they are saying. And so it was absolutely, that's relevant, I think, to go towards Trump's motive and intent. Also in this filing, in this case, Jack Smith indicated he had evidence of Trump's phone records, and it's said that it specifically identifies the periods of time in which the phone was unlocked and when he used Twitter, and the fact that he used his own personal phone instead of a government-issued phone to make calls so as to not be detected. This kind of thing, when you like use burner phones, because that's essentially what Trump was doing, right? When you work for the government, you get a secure government-issued phone. He's using his own personal phone so that it can't be detected. And so as prosecutors, we call that consciousness of guilt, right? Jen Rubin goes on to talk about how the most relevant and significant, the most significant revelation comes from Dan Scavino. And let's remember who Dan Scavino is. He began working for Trump as a teenager over 3 decades ago, and he worked his way up with Trump to be a deputy chief of staff. And he's now a paid advisor on his reelection campaign. And ABC News has reported that Scavino wouldn't speak with the House Select Committee, but after a judge overruled his claims of executive privilege, he had to speak with Smith's team. He could have been subpoenaed, but he also could have been held in contempt if he didn't. Maybe he was subpoenaed. I don't know. And what did ABC News report that Scavino told Smith? That during the assault on the Capitol, on January 6th, both Scavino and another Trump aide, Nick Luna, heard Trump dismiss concerns about Pence's safety, saying, "So what?" Right? So what? Apparently, that he doesn't care about Pence's safety. And again, more evidence that Trump supported this violence. And Scavino allegedly will testify for Smith that Trump was very angry on January 6th, not about the violence, but that the election was stolen from him and that the supporters who were angry that the supporters who were there were angry on Trump's behalf. So again, that's more proof of intent that he was going to let his supporters shut down the electoral vote count. And all of these events preceded Trump's 2/24 tweet, egging on the crowd to go after Pence when he said, Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones, which they asked to previously certify. USA demands the truth. And Jen Rubin goes on to talk about in her article that Luna will also provide evidence about a draft tweet Trump showed him that read, "These are the..." So think about it. Trump showed Nick Luna a draft tweet that didn't get sent out, that these are the things and events that happened when a sacred landslide election victory is so unceremoniously and viciously stripped away from great patriots. Remember this day forever. Now, there's no way, this is me now talking, not Jen Rubin or anybody else. There's no way that Nick Luna remembers word for word that a draft tweet said that these are the things and events that happen when a scared landslide election victory is so unceremoniously and viciously stripped away from great patriots. Remember this day forever. It's very specific, right? And Jack Smith put that language in his filing. Very specific. What that tells me is that Jack Smith has the draft tweet. And if you recall, when we looked at the search warrant that Jack Smith applied for and that we got to see in some of his filings, we saw that one of the things when he subpoenaed Twitter was he was looking for draft tweets. So clearly he received the drafts. It corroborated what Nick Luna must have told Jack Smith, that there was a draft tweet and it said something like this. And Jack Smith has the language, which is why he put it in his filing. Because again, as a prosecutor, you wouldn't lock yourself into exact language if you didn't have it. And you wouldn't say that you had this if you didn't. So clearly, he has Trump's draft tweet, and it corroborates Nick Luna. So many people thought Smith would have difficulty tying Trump to the violence and proving intent, but through Smith's violence, we have learned that Smith has gained powerful evidence to prove his case. And there you have it. This is why Trump doesn't want a trial ever to happen, because the proof will be overwhelming. And that's why he's instead arguing that he's absolutely immune, because if instead he has to face a jury, he will be convicted because he is guilty. So instead he wants to be immune. I'm Karen Friedman Agnifilo. Thanks for joining me every Wednesday and Saturday on Legal AF.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.